L.B. Sullivan was an elected official, and his title was Commissioner of Public Affairs. He looked over the police station and the fire department. He filed a lawsuit against the New York Times in Montgomery, Alabama, and he won $500,000 for damages and was upheld by the Alabama Supreme Court. His concern was the full-page advertisement titled, "Heed Their Rising Voices." It used keywords like nonviolent, demonstrations, and human dignity. The advertisement also stated the Southern Negroes were being met with turmoil and an unexpected wave of terror. Mr. Sullivan feels that that's not all simply true. He had issues with the third and the sixth paragraphs on the advertisement. On the third paragraph says that students sang "My Country, 'Tis of Thee" at the state capitol steps. It caused expulsions and police surrounding the school with guns. When the students continued to protest by not registering, they locked the dining hall to starve them into submission. Paragraph 6 states that Martin Luther King has been bombed at his home and has been arrested 7 times. Mr. Sullivan feels that when they say police, which he is the boss of, is a direct reflection on him. And when "they" and "Southern violators" is used in paragraph 6, it is a target towards him and the Montgomery, Alabama Police Department. There were some discrepancies in the writings for those 2 paragraphs, like the song that was sang at the protest and the dining hall being locked to starve students into submission, or how many times Dr. King has actually been arrested and why. But the judge says mere negligence is not evidence of actual malice. In the long run, Mr. Sullivan couldn't prove his reputation had been damaged from the advertisement. In general, a defamation statement is a false statement of fact that is negligently communicated or published to a third party and that causes injury or damage to the subject of the statement. And with knowledge, it was false, and not caring is the definition of malice. For a public official to recover in a defamation action involving his official conduct, malice must be proved. Without the showing of malice, the Supreme Court felt that a defamation action in this case would severely cripple the safeguards of freedom of speech and expression that are guaranteed in the First Amendment of the Constitution and applicable to the states via the 14th Amendment of the Constitution. Elmer Gertz was an attorney representing the Nelson family in a civil case against Nucio. He was considered a private person. Nucio was a Chicago police officer who shot and killed a man named Nelson. American Opinion, a magazine company wrote an article stating Nucio had false testimony at his criminal trial, and his prosecution was part of the communist campaign against the police. Even though Gertz had minimal involvement in the case, American Opinion named him as the architect of the frame-up and labeled him as a communist frontrunner. The magazine appeared to be making most things up about Gertz, besides being part of the National Lawyers Guild 15 years prior. This creates a large impact on Gertz's career, especially to practice law. Welch seemed reckless and careless in his writing. It's imperative to get the facts and communicate the narrative properly. Defamation in Florida. Under Florida law, the elements of defamation claim are that the defendant published a false statement about the plaintiff to a third party, and the falsity of the statement caused injury to the plaintiff. I realized from these two cases that it is imperative that you focus on the facts and you maintain your reputation. Building long-standing relationships is the way to go.